Okay, sorry. All right.
Speech of that particular platform, that's a real problem.
It's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record because the speaker that is
let me just write
speech platforms. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record because the speaker that is ultimately being shut down, they don't like the speech of that particular platform, that's a real problem.
So it may be a real problem or may not, but I just...
Good one. Yeah, okay. The law imposes a direct regulation on a third party. This regulation shuts down someone else's speech, and the law is passed for viewpoint-based reasons. Yes, these are the three. Okay. So the law imposes a direct regulation on a third party. That's the TikTok survival depends on the foreign party's response to said lawsuit, correct? This regulation shuts down somebody else's speech. The TikTok speech is speech being access to / control of the algorithm, and their speech is shut down if they lose access to this. That's what this means, right? And then the law is passed for viewpoint-based reasons. The law is passed by the government is implicating content / freedom of speech. So because they're targeting like social media companies or whatever, it's clearly implicating a type of speech here. It's not just on all companies. It's targeting like a particular type of speech, right? So, okay, yeah. Okay. Sorry, Jason. All right.
Just am wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like ACARA. And what ACARA says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict scrutiny.
So then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on expression, whether it's based on anything else.
So, Your Honor, I disagree. And I think if you take a step back and look at this record, I think it is quite clear that it is focused on both current and potential future content on TikTok, TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated.
Justice Thomas, anything further? Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress views?
Content moderation or covert manipulation. Was there anything in the act about that explicitly? Covert. I don't know what he's referring to there, but I don't know. This might be a dumb question, but why is precedent so important to ruling and judges more generally? Like, why do we lend so much credence to what people already thought. Because the U.S. it's complicated, but part of the U.S.'s historical tradition in law is rooted in the concept of common law, which means that we kind of look to prior rulings and judges to fill out exactly how we interpret a lot of the civil law or codified law that we have in the United States. So prior decisions that judges made in terms of how they might interpret a particular statute or apply a particular statute become incredibly important to future judges. It's just how the U.S., I think that's like part of a theory of common law, basically.
Viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens. And they said, this is the worst offender, and we're going to require divestiture by this offender.
That reminds me, is that one conservative lawyer that you argued with correct about common law? Did you look into it after the fact? I tried, so I thought this was a thing I could read a quick Westlaw thing on. Common law and civil law and the differences between the two are, there's a whole ass like fucking theory of both of these things. But common law, I think, implies a lot more that the United States doesn't do. So like, for instance, like the idea that like a judge himself could just basically say, I think this is what this thing is like. And the idea that we do have codified statutes, which I think is considered part of like a civil law system. But I think, ask somebody in law school. I don't know what they teach in law school. If they teach you that like, oh, America is a common law system, because we have aspects, I think, of both systems, I think. But I don't know if there's somebody who went to law school who can say that or whatever. I don't know what the answer is there.
Arsenal of popular application from gathering an arsenal of information about American citizens. And they said, this is the worst offender, and we're going to require divestiture by this offender. Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Yeah. Yes, there would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments. I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you
All right, but you're changing the hypothetical by injecting congressional concern about the
Okay, well, I'll put that to the side.
So what would your argument be? It would be an equal protection argument?
No, I'd still be saying that ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss it out, to suss out whether the asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have...
When he says we have to suss out if the asserted interest is the actual interest, like it could be that maybe I go to a city and I see that all the white people work an engineering job and all the black people work an NBA job. Okay, make it however you want, right? And I say like, oh, I'm going to pass a law that says all black people are slaves again. Well, the court would look at that and they would say, well, we're implicating fundamental rights. You can't do this ever. Well, that wouldn't even survive. But you make a law saying like all black people have to, say the Pledge of Allegiance 15 times a day while they're walking up and down the street or else a cop can kill you, okay? Right? That would be like, well, no, you can't do that. Obviously, you can't target black people here. You're implicating fundamental rights. You're implicating class of people. It's not good. Sus class, not good, right? But what if you said, okay, true. We're not going to target all black people. We're just going to target all NBA players. Get it? Look at how cute that is, right? I think this is the second prong of the intermediate scrutiny argument. It's like, well, hold on. Are the means by which you're targeting somebody substantially related interest? Wait, that's not true. Hold on, wait. This might even be part of the strict scrutiny thing. Wait. This might be under the least restrictive means part or something. No, wait, fuck. I feel like I read a thing that like you have to show that the thing that you've done is not like also like tailored to something that would implicate another class or something, or implicate like a thing that would cause an elevated standard of review. Fuck, I don't remember what this would implicate. I know I read this somewhere recently. You can't like target somebody using like another thing. You can't be like clever. Like if in effect you end up targeting a thing that would cause a heightened review, I think that heightened standard would come into effect. I know this came up in although I don't know if this became a federal case or not, that North Carolina voter ID shot, but.
A couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties to China.
You say, I don't want to prolong this too much. You say this is not like Arcara, I think primarily because you say that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like Arcara for a much more fundamental sense. Arcara involved a totally speech-neutral law. It didn't go after speakers at all. If you had a law in Arcara that said we're going to prohibit prostitution in bookstores only, then I think that Arcara would have come out differently. There would have at least been, some kind of intermediate scrutiny.
I don't know anything about this other case.
That's the law that I think is your hypothetical.
Walk away from the hypothetical that I posed for the purpose of narrowing in on what your argument is. I understood you to say that that would not be a solution to the problem because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think that I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the reason why Arcara is different is because Arcara didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers or in this particular speaker. And I think that would trigger at the very least intermediate scrutiny.
All right, thank you.
Justice Sotomayor?
That goes to my question, which is, Justice, the Chief Justice asked you whether or not we've ever had a case where pure ownership was at issue and not speech. And I don't think we've had one like that, you're right, but I don't think that the question gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
Correct.
Right. One of the three prongs that he brought up is the law is passed for like viewpoint-based reasons, speech-based reasons.
Right. So if I get past that, if I go to Justice.
How come we can hear them but not see them? Do they not let cameras in? No, they train a lot. I think ventriloquism is one of the big requirements for being a Supreme Court justice. This is actually them speaking. Their lips just don't move.
Correct.
All right. So if I get past that, if I go to Justice Alito's point, which is I don't think it's just about speech, it's about data control. Mm-hmm. If it's about data control, and assume, for the sake of argument, that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, I think they'd be very similar because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I could unpack that a little.
No, I'm not going to,
Sure.
because we're going to run out of time, because we're going to need to figure out what intermediate scrutiny means. But I'm not sure it means what you do, which is I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny. In fact, our cases have said we have to use a reasonable means.
And if I could respond to that point specifically, I completely agree it's not a least restrictive means alternative, Your Honor, but you do have to at least consider alternatives. Here, if the concern, let's take the data security concern, which you put your finger on.
I know you want to keep going on, but I can't let you, because I can't monopolize the argument, okay? But let me just get to the bottom of that, all right? You seem to suggest that Congress has to actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am
if
not
from the record it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that.
Is this a partisan issue, or is this a rare case of Democrats and Republicans both wanting it banned? I think initially they did, but my guess is going to be that Donald Trump doesn't want TikTok banned, but I don't know if he said anything too recent about it. I know a little bit ago he kind of said this, but Trump is retarded. But Trump was like, oh, I thought TikTok was for me. I don't think we should ban that. So I don't know I think that as long as the content on TikTok seems to be supportive of Donald Trump, I think he would probably be okay with keeping it. But I don't know if he's made anything more recent about that. However, a lot of the billionaire donor class, the financial interests behind Trump, would definitely want TikTok banned, which could also be part of why Zuckerberg and Elon Suck are all sucking Donald Trump now. Because if TikTok gets banned, it's really good for Twitter, because now it's just a whole new social media platform that people move off of. It's really good for Instagram, because if I had to guess, I don't know if anybody was marketing on this, Instagram Reels are probably the biggest competitor to TikTok and TikTok-like stories or whatever, would be my guess. So if you knock out TikTok, then Instagram Reels are in a real good place. Also, didn't Facebook also acquire Snapchat? Is Snapchat owned by Facebook? God, it's so gross. I just said they're gross. That's not even true. Never mind. Oh, no. They own, I'm mixing them up with, is it WhatsApp or what? There's another thing that was acquired by Facebook. What am I thinking of? WhatsApp, I think. Yeah. WhatsApp doesn't implicate it all here, but yeah, in a way, this is the protectionism that the big domestic companies want, because getting rid of TikTok or making it so that TikTok is now acquirable somehow because there's no way that TikTok runs profitably, would be my guess. I don't know. This seems to be the case. So now TikTok is just going to be up for grabs between whichever one of the 4 huge companies in the U.S. wants to buy it or something. That's just such a great thing for domestic companies.
That might be enough.
Now
but
I take
here
that.
on the
Now let me
key-
go to the next question and the last.
If I could, Your Honor, just one sentence. If on the key less restrictive alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even considered it. And that's why it would fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we can go past that.
That's incorrect, actually.
No, because the NSA doesn't.
I'm not talking about the NSA.
Or even anything else. But putting that aside, one last question. Assuming that the covert manipulation issue is one, I think that what remains is, to the Chief's question and Justice Alito's questions, if the covert manipulation is a concern, then the question becomes what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm and promote whatever speech it wants to promote through the algorithm, correct?
It doesn't prohibit.
Wait, does she really think it's called algorithm? It sounds like she said that twice. Oh, no.
Promote whatever speech it wants to promote through the algorithm,
It
correct?
doesn't permit them to speak to the American public through the algorithm.
Right.
And promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to
with-
ask,
Would you personally be happy about a TikTok ban? Like personally, like absent any legal considerations? I don't know, probably, I guess. I don't know how successful, it's one less platform I'd have to worry about expanding to, so.
Secret.
she about that. How do you disentangle the two things?
Thank you, Your Honor.
Legally, I don't know. This is an interesting case. I'm generally a free speech person, though, so I think you need to make pretty compelling arguments to be opposed to freedom of speech stuff, obviously. But I don't know. I'm not sure.
Justice Kate? Justice Gorsuch? Justice Kavanaugh?
Just on the data collection interest, I think Congress and the President were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people.
But actually, I'm curious. You say one less platform. I know you're kind of memeing, but without legal point, isn't this exactly what you support? Less concentration into bigger companies? What are you talking about? If TikTok gets banned, it's literally more concentration into bigger companies.
People who a generation from now will be working in the FBI or the CIA or in the State Department.
Not banning it. Oh, sure. Yeah, but I mean, if they're literally working with China or some bullshit, I don't know.
Is that not a realistic assessment by Congress and the President of the risks here?
Well, Your Honor, I'm not disputing the risks. I'm disputing the means that they have chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance. You can't give it to China. You can't give it to Google. You can't give it to Amazon. You cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative. And so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test, but you got to at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the President were concerned about. You're just saying the means they chose to address that risk were incorrect,
So
not permissible.
I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in and said, we passed this law, one for data security.
I understand that, but just on the data collection, that seems like a huge concern for the future of the country.
And Your Honor, again, it is a concern, two responses. First, it is a concern that can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated from sharing sensitive user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And that's the minimum that Congress has to do under the First Amendment. It's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying to TikTok's employees, you're essentially going to get massive fines, potentially jail sentences if you share any of that sensitive user data with anybody. Not TikTok, not ByteDance, not China, not anybody else in the world. Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th if you lose this case? Can you just spell that out?
At least as I understand it,
TikTok would probably cease to function, and then it would probably cease to exist, right?
we go dark.
Yeah.
Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless
Presidential.
Not just a divestiture, though. It has to be a divestiture, then it has to be a massive coordinated effort. It probably won't be able to be completed in time, so they would have to ask for an injunction against like the penalties, and they would have to, like, yeah.
President
extension.
Trump exercises his authority to extend it by but he can't do that on January 19th. On January 19th, we still have President Biden, and on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here. And
because the injury would be not irreparable, but it would be a significant injury. Yeah.
simply buy everybody a little breathing space. This is an
What
enormously...
do you mean by shutdown, too? Can you just spell that out?
What would they even be allowed to do? I don't even know if they'd be allowed to serve a web page saying you can't access anything right now. Well, I guess they would, because then they'd no longer be a social media company or something, right? We need to rest real quick. 1 second. Oh, Jesus.
So
If you
the
can.
the app is not available in the app stores. That's at a minimum. But in addition, what the act says is that all of the other types of service.
Everybody that works with TikTok needs to immediately stop working with TikTok. Oh, that could implicate so many things. So like if you log in using an OAuth, you might be disallowed from working with TikTok. So you can't even log into your account if you use your email address from Google or whatever else. Like all of these companies have to cut contact.
Providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously consequential decision, and I think all would benefit if it weren't necessary.
Thank you.
Justice Barrett?
So I just want to, it's kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you a different question than I did before about the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok.
Because they would no longer be one of the defined parties or whatever. What do you call it? They would no longer be a, what's the name of it? What do you call it? They wouldn't be a covered company because they wouldn't be a foreign adversary controlled application.
But the law, not ByteDance.
But that's
the
because of
law requires
ByteDance's
TikTok to
choice,
shut down.
right? I mean,
well,
this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for the reality of third-party choices and the choices of third parties that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
Right.
Oh my God, I'm so fucking stupid. I hate my life. I'm sorry. Why do I even have a schedule? I put him on the schedule, and I even put it in the stream schedule. No one in chat says anything. Fuck you guys. You guys don't even use the schedule. You don't look at the schedule. You don't want a schedule. You want me not doing the schedule. You need me. Fuck you guys. Fuck, I thought he would have responded to my last email. I think I was relying on that. Dumb. Well, let's see if he responds. Good luck.
Right.
Step two, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do is you ask, is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content-based on its face because it says what it says. We know it's content-based in its motivation because the government concedes it's content-based in its motivation.
Well, that's not quite what I'm asking. I mean,
I
let's
think
see, that's the dispute between
Yeah.
you and the government is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is in fact content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable.
Is Section 230 just null and void here, or how is this factoring in? Am I retarded? You'd be applying that at a different level. It's not relevant to this, I don't think, but we'll see. Maybe it'll get brought up.
They will mix around their videos in a way that is too pro-Chinese or too anti-American,
Okay,
and that is TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons.
Is there like a constitutional limit that says that oral arguments are only like an hour per party or something? Is that like a thing, or is it just like a rule they have? Is that why they're trying to go over time? Or
The first is that the underlying source code That's the source code that comes in here and then has to be converted.
But
and
that's what
executed
Justice
with
Gorsuch
those.
said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source code.
So, well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing of content, that was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up for our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say, we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech. You say you have...
This is like arguably maybe the most important question. I'm saying that, but like, I don't know what the fuck do I know? That like, if there isn't a burden on the speech, like if this is my guess as a non-lawyer dipshit, if it's an intermediate scrutiny or rational basis, then they auto lose 1 trillion%. They're auto lost. I think the only chance that this has of winning is if they can argue for a strict scrutiny review, because that puts the highest burden on the government. I don't even know if they're going to win that, but that's probably the only path to victory, right? But in order for it to be a strict scrutiny review, they have to say that their speech is being attacked. And that's why a lot of this conversation is going back to, well, hold on. Is this really directly burdening your freedom of speech? Just because the company above you has to divest from you? Is it really directly implicating your right to freedom of speech just because of your relationship with another company? That's why they keep going back to this line of argumentation, I think, because it's pretty important. It's pretty important.
Have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations. And the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture.
Yes, but his argument has to be, this is what they're trying to argue, is that, sure, that's true, but the termination of our relationship is based on our speech. You're trying to make us divest because you don't like that there might be some speech that we give, because if it was all, peachy about the United States, we wouldn't be here right now. It's because you don't like the Chinese propaganda that you're accusing us of spreading on this platform. You're implicating free speech by doing that. It's the argument that he's trying to make on this.
So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says to TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says.
That's not at all what it's saying. I don't know why. I don't know if he just had a fucking stroke. That's the worst and dumbest argument. I don't know why he just said that. The argument is that they're only asking us to terminate our association with ByteDance because of our content, because of our viewpoint, because of our speech. I don't know why he just said that. Oof. I don't know. I have no idea why he just said that.
Divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok...
Because TikTok could just No. Hold on. No. I'm so sorry. Wait, no. That is kind of true. Well, there's one more part to it. They have to go mute if ByteDance doesn't divest. Or was she saying if they divest? Because if ByteDance doesn't divest, then TikTok has to shut down. There's nothing they can do. It's dependent on the actions of a third party, right?
Were to post divestiture or whatever, pre-divestiture, come up with its own algorithm, right?
No, because ByteDance has to divest. ByteDance has to divest. TikTok can't make that decision unless there's some corporate thing that I don't understand, which is entirely possible. I've never divested a company before.
Then when the divestiture happened, it could still operate. It doesn't say TikTok, you
I
can't
think that's
speak.
theoretically correct, Your Honor, but
Yes.
I think that also underscores the content-based nature of the restriction.
No,
We have
but
to
the
change
fact,
it.
excuse me,
the-
the fact that
The
that's
content-based, this is the one that he's supposed to argue, yeah.
true suggests that you're wrong about the statute being read as saying TikTok, you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
But ByteDance could say, I don't think this is the key thing that the attorney should be focused on. I understand why Jackson is on this, because from that perspective, it's not really a freedom of speech or content thing, right?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay, well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations.
Yeah, this is all easy to do, of course. I don't know why. Is freedom of association, is that even like a fucking thing in the United, or I don't even know what the fuck that means. That sounds like a sovereign citizen thing. What the fuck is freedom of association? I don't know what that means. I don't know why he would even bite at that argument at all. But there might be really good reasons, by the way. Maybe there's case law or some shit that I don't fucking know anything about. Maybe there are really good reasons for it, but...
prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied.
First Amendment? Wait, what is... I don't have these memorized. Is there, and your freedom to associate with foreign, or the freedom of association at all, or what? Where's the text? Why is it that when I go to the Wikipedia for this, shouldn't the text of the First Amendment literally be like the first section? Good. True. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging, meaning placing restrictions on, the freedom of speech or of the press or the right of the people peacefully to assemble and to petition the government for a redress of grievances. Where are we reading the right of free association, especially with foreign company? I don't think that's... unless we're saying to assemble? Are we talking like corporate? This just sounds like basically the people having the right to, I guess, like make their grievances with the government known as like a group or whatever. I don't. But maybe there's a way this could have been read into. Hold on. The First Amendment protects many activities such as blah, 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 blah. The right of expressive association is the focus of this set of essays. The court has also recognized a personal liberty interest in certain intimate human relationships. Intimate association discussed at the end. The court did not always recognize constitutional right of association. I don't think it's sided with the companies. I don't believe this. Or even if it does, even if it implicates that, it wouldn't be the right of free association with foreign companies, no? Or maybe, I don't know. Don't care.
The material support statute most definitely applied.
And ultimately upheld the loss.
Hold on. Okay.
So fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical, where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden.
That feels like a really, really, really weak argument here. I don't understand why this is being presented. Maybe it's for reasons I don't get, but I don't know why. Because any sanction or anything restricting any foreign company would dictate some of your speech a little bit, but I don't know. I don't understand this.
On TikTok incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security, and two, we hate the speech on TikTok. The data security wouldn't alone sustain that law under cases like Mount Pleasant.
I understand, but why you're equating we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content, and I'm just trying to understand why.
Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content. That is core protected speech.
Yes.
That's why they put so much weight on this mere covertness.
Right, but that analysis is just about content-based versus content-neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world, okay? I'm assuming that you're right, that strict scrutiny applies, and now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in
he concedes point one, right? Prong one is, of course, the government has a compelling interest, but it doesn't satisfy prong two that the law is narrowly tailored enough, right? Isn't that the
colloquy with Justice Kavanaugh to say is a risk, and we are concerned based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation is not just not a compelling governmental interest, it is an impermissible governmental interest. You could not go to CNN or Fox News and say, we're going to regulate you because you're manipulating the content in the way that we don't like.
But it's not just in the way that we don't like, it's for national security purposes, no?
That is per se impermissible.
Okay, can I just ask you one last thing? You say, with respect to the tailoring issue, that disclosure, you think, is a possible, more narrowly tailored way of handling some of this. And I guess I'm just wondering whether disclosure under this court's case law and the law of other lower courts doesn't carry its own First Amendment complications. That wouldn't we have compelled speech problems if disclosure was required in this situation?
Sure, Your Honor. Now, look, I might think so because I think that the factual predicate is wrong, but they think the factual predicate is right. And if the factual predicate is right, then there are no First Amendment problems at all under Zauder and the cases that you're suggesting. And that underscores the larger problem here. Not all disclosures are perfect. I'm not here to argue that they are. But you've always got to consider what the alternative is. And here the alternative is shutting down one of the largest speech platforms in America. The reason there's no evidence in this record as to disclosures is because Congress never even undertook that balancing in the first place.
Thank you.
The bare minimum that has to be done before we take an unprecedented step of shutting down the voices of 170 million Americans.
Thank you.
Thank you, counsel.
All right. Okay, so obviously they're asking questions to this side, so they're going to be more brutal towards the plaintiff here, which is understandable because they're asking questions, although they don't have to be as brutal if they agree. It feels like TikTok is going away. That's the feeling I have. Woo! But now we're going to hear the defense's side on this.
Mr. Fisher?
Mr. Chief Justice, and may it please the court, wholly apart from the company's legal interests here, the act directly restricts...
Oh, wait. Attorney for TikTok content creator Brian Firebaugh. Is he like a TikToker?
the rights, the First Amendment rights of American creators to participate and speak.
Oh, wait. Jeffrey Fisher is the TikTok guy. I'm sorry. Jeffrey Fisher is the attorney, but he's representing Brian Firebaugh.
And with a court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the act fails that test, and indeed any level of scrutiny under this court's case law, because the act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with this implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we've faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court.
Oh, no. Wait, who is this guy? This guy sounds retarded. I might be retarded, by the way. That just sounded like a dog shit argument to me. I feel like we're in very ideological First Amendment, free speech protects everything grounds. And it doesn't, but I don't know which case he's representing either as well, though. I didn't read his case. So maybe it's a totally different thing than the TikTok thing. Oof, I don't know if I want my wagon hitched to this guy, though, after the other dude, but we'll see.
Court's questions.
How exactly are the creators' speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other Americans.
But it doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or...
No, not giving Thomas the opportunity to make coherent fucking arguments. No.
There will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work.
I don't know how this would ever regulate the speech of the people on TikTok. I don't even know how you could possibly get there. This has nothing to do with the creators. Even if we assume that the creators are affected by this has nothing to do with the creators' right to associate with TikTok. This is like an incidental of an incidental. I feel like this is so off of whatever, but I don't know, we'll see.
Work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform, and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with.
No shot. Is that true? Wouldn't that necessarily mean every single company that gets shut down or sold, every single person who posts on that platform has a First Amendment claim? That seems like an insane argument to me, but I don't know, I could be wrong.
Engaging on current events, news, politics, would have a First Amendment claim to work with
using that
particular
argument,
publisher.
you could have said that about the breakup of AT&T.
Yeah, of any company ever.
You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X, or the current owner of Fox News, or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States?
They absolutely can. I don't think you can directly communicate with or coordinate with like terrorist organizations. I don't believe you can. I think it's illegal in the U.S.
I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right, so I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine U.S. leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit more?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the cases.
Is he familiar with the Holder case or not at all? I'm not at all, so. But it sounds like he's not referencing it or naming anything about that case to draw the parallels or to make the distinction. So I don't know.
Over, or you don't get to associate. You have to dig underneath what is the national security claim, and what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it terrorism? Is it where our battleships are located? Is it war?
Justice Kavanaugh presented a number of potential risks, right, with foreign adversaries using covert.
It doesn't matter what Kavanaugh says. You have to consult the record of the case itself. These claims are ones that the government needs to make, not the justices, right?
Manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines.
People are saying the court can give reasons if the government doesn't. For a strict scrutiny case, though, I feel like that's kind of inappropriate, but I could be fucking retarded. Who knows? Maybe they always do this.
Trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now, there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling, but that's not the question. You just don't ask in the air, was Congress worried about data security or could it reasonably be worried about data security? You say, can this act, the act before you, be sustained on data security grounds? And our answer to that has to be no. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the
Wait, I didn't even know that. Was that part of this? That's, oh, okay. That is really weird. That shouldn't be in here. That does seem tainting. No, hold on. I'm so sorry. Wait, I feel like he misread this. Hold on. Never mind. I understand. One second. Oh.